Hey guys, Mark Smith here. Just really quick, when I shot the video you're about to watch, it was literally right before I got the huge news out of the Northern District of New York with that big win dealing with carriage of firearms in New York State. So this video doesn't account for that huge win. In my view, that's a huge win, in addition to the wins that I'm going to discuss here of how we've been kicking butt in the Second Amendment community in the courts for the last 90 days since the NYSRPA versus Bruen case was decided. So hope you enjoy the video. We'll talk soon.
Do not believe the hype. The anti-gunners like to think that they're on the move, but they are not. They're getting spanked, and it's going to get worse for them. The trend is our friend when it comes to advancing gun rights in America, especially in the post-Bruen world. I'm going to give you just a series of examples of what's already happened in the last 90 days in America's courts to show you that the Second Amendment right to keep and bear arms is on the march, and that will continue. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and best-selling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms, and feel free to join us on Twitter and other places where we're working hard to expand the scope of the information on this channel. About 90 days ago, the United States Supreme Court issued their decision in NYSRPA versus Bruen, and since then, the Second Amendment has been on a winning streak in America's courts, and I suspect it's going to continue. In fact, I think the rate of victories for us is going to actually increase. But let's just do a little bit of recap. Let's go to the highlight reels for the last 90 days in America's courts to show you just how great things have been going for the Second Amendment community and why I think it's going to continue. I want to hit the highlights because there's a lot of rhetoric out there in the anti-gun media about how, like, the gun control movement, there's a debate. There's no debate. The gun controllers are getting spanked in the courts. There's no debate, nowhere, no how to disagree with that. So let's just go through the list. First of all, since Bruen was decided, let's just start with Colorado. I think it's an exciting example. Why is that? In Colorado, we've had two separate cases. One in the city of Boulder, Colorado, one in the city of Superior, Colorado. In both cases, and both in federal court, so-called assault weapon bans were enjoined, barred from being enforced on the grounds that they violated the Second Amendment. That's right, two separate so-called assault weapon cases, which are just semi-automatic rifle cases, as you know, semi-automatic rifle bans, were enjoined for violating the Second Amendment. But that's not what's exciting. That's great news, but that's not even the most exciting part. Do you know who the judges that actually enjoined these laws were in Colorado in federal court? One was Judge Raymond Moore, appointed to the federal bench by Barack Obama, the greatest gun salesperson in American history, enjoined and thwarted the so-called assault weapon ban in Colorado on the grounds it violated the Second Amendment. And the other judge, Judge Charlotte Sweeney. Do you know who Judge Charlotte Sweeney is? A federal judge in Colorado appointed to the federal bench by Joe Biden. So you have a world in which Joe Biden appointees to the federal bench and Barack Obama appointees to the federal bench are striking down assault weapon bans, so-called assault weapon bans, on the grounds that violate the Second Amendment. That is a great start in the state of Colorado, but it gets better and better. Let's turn down to Texas, where we have a federal court has said that a ban on 18 to 20-year-olds being allowed to carry guns in public under the concealed carry rules in the state of Texas, that law that barred them from carrying guns in Texas was unconstitutional under the Second Amendment. That's right. Judge Pittman in the Northern District of Texas in the last 90 days, immediately after Bruen, says that 18 to 20-year-olds in Texas are allowed to carry guns because they are part of we the people, as in the right of the people to keep and bear arms, and they are indeed part of the people. Another major victory for the Second Amendment. But it gets better and better and better, folks. Also in Texas, Judge David Counts, another Texas federal judge, these are federal judges, basically struck down a federal statute, 18 U.S.C. 922N, that provides that if you've been accused of a crime where you can go to jail for a year or more, meaning you've been indicted by the federal government, but you haven't been convicted, once you've been indicted, you are not allowed to take possession from an FFL of firearm. Guess what? Federal Judge David Counts in Texas says no can do. No can do. 18 U.S.C. 922N is unconstitutional under the Second Amendment. cannot be enforced. That's right, folks. Another major victory in just the 90 days since Bruen. But it gets even better and better, folks. In Delaware, the ghost guns, which is a propaganda term for just basically guns that don't have serial numbers that you and I make in our own homes. Huge victory. Huge victory. Case of Rigby versus Jennings in the federal district court in Delaware. In the last 90 days since the decision in NYSRPA versus Bruen, the Judge Mary Ellen Norica, came out with a decision that says you and I, as Americans, under the Second Amendment's right to keep and bear arms, have a right to make our own guns. The fact that we have the right to keep, which means to possess, and the right to bear, which means to carry, guns, does not require us to go to a retailer and buy guns. We can do it ourselves. And that is the first decision in American history that actually says that. Within the last 90 days, the 90 days since NYSRPA versus Bruen was decided, and that was decided in a federal district court where? In the state of Delaware, the hometown, the home state of Joe Biden. But it gets better. Let's turn to the Commonwealth of Virginia, the city of Winchester, Virginia. Just 2 weeks ago, within the 90 days of the decision in Bruen, said that a ban on firearms in public parks and a ban on firearms at public assemblies like parades and the like was unconstitutional under the Second Amendment's right to keep and bear arms. Because those so-called sensitive places, as defined by the city of Winchester, cannot be deemed sensitive places under NYSRPA versus Bruen. So in the city of Winchester, Virginia, in the 90 days after Bruen, a ban on guns in public parks and in public assemblies, public places, public events like fairs and whatnot, and adjacent streets, struck down, unconstitutional under the Second Amendment, just about 10 days ago. And then, of course, we have in New York, we're waiting for the next round, the next major decision, which I think will be quite favorable, in Anna Young versus Bruen. It's the new, different title for that case, but you get the point. But in Anna Young versus Bruen, you remember that case in the Northern District of New York. A federal district court judge said, even though the plaintiffs did not have standing, he wrote like 25 or 30 pages explaining in extreme detail that these new anti-gun laws, including to carriage and their discretionary licensing regime that New York has adopted after the Bruen decision was decided, are all likely unconstitutional under the Second Amendment. That is another huge victory, even though the plaintiff's lack of standing prevented that order from going into effect. It is a sign of things to come. And that judge has another case right now involving the Second Amendment, and I think those plaintiffs definitely have standing. So let's see what happens there. And last but not least, remember we talk on this channel that dumb people cannot learn from their own mistakes. Smart people learn from their own mistakes, and wise people learn from the mistakes of others. So let us turn to the District of Columbia, where the District of Columbia has changed a gun law on an emergency basis voluntarily because they feared getting their butt kicked in court, which was going to happen imminently. Down there in D.C., they had a law for many, many, many years, one of the few anti-arsenal laws in the United States. An anti-arsenal law, which you don't hear a lot about because they're popular in Europe, but not as popular here. An anti-arsenal law restricts the number of guns you can own and the amount of ammunition you can have. It's called anti-arsenal, prevents you from developing an arsenal. Generally doesn't exist in the United States, but in D.C. there was an anti-arsenal law. And the way this law worked, it says that you are not allowed to carry on your body more than 20 rounds of ammunition at any one time. Guess what? Well, D.C. was sued by Dick Heller of Heller versus D.C. fame. He sued over this law after the Bruen decision was released. And guess what happened? D.C. just says, no mas, no mas. We give up. We're going to change our rules and let people carry more than 20 rounds. And when they have a concealed carry permit, we're going to let them carry more than 20 rounds. We're not going to limit the number of rounds they carry ever again because we see the handwriting on the wall. We're going to get our butt kicked by the Second Amendment community, so we are surrendering. And that's exactly what the District of Columbia did. Okay, so this is a quick rundown in the last 90 days, since NYSRPA versus Bruen was decided. These are major, major court victories. I would hazard a guess that we have more Second Amendment court victories in the last 90 days than we had in the prior 10 years combined. I haven't done the math, but I'm guessing that could very well be true. And there's more to come. You just wait. We talked about this before Bruen came down, all the different reasons why this was going to happen. It is now happening. The trend is our friend. Great news. Never forget this. And by the way, for those of you in places like California and New York, this trend is coming your way. Don't kid yourself. I know those places have problematic courts, especially in California, but at some point, reality will set in when it comes to those judges in those places. And we're going to talk about that and follow those stories as they unfold. Okay, hope you learned a little bit something about here. The great news in the last 90 days, there's a lot more work to be done. We have a lot of battles to fight, but the last 90 days are a great trend. So let's see what happens. And again, thanks for joining us here. If you haven't subscribed to the Four Boxes Diner, please do so, and we'll see you again here soon at the Four Boxes Diner.
Orders up. Table 2A.